Habeas corpus, redirected from writ of habeas corpus, also found in dictionary, thesaurus, financial, acronyms, encyclopedia, Wikipedia. Related to writ of habeas corpus, writ of mandamus habeas corpus Latin, you have the body. A writ, court order, that commands an individual or a government official who has restrained another to produce the prisoner at a designated time and place so that the court can determine the legality of custody and decide whether to order the prisoner's release. A writ of habeas corpus directs a person, usually a prison warden, to produce the prisoner and justify the prisoner's detention. If the prisoner argues successfully that the incarceration is in violation of a constitutional right, the court may order the prisoner's release. Habeas corpus relief also may be used to obtain custody of a child or to gain the release of a detained person who is insane, is a drug addict, or has an infectious disease. Usually, however, it is a response to imprisonment by the criminal justice system. A writ of habeas corpus is authorized by statute in federal courts and in all state courts. An inmate in state or federal prison asks for the writ by filing a petition with the court that sentenced him or her. In most states, and in federal courts, the inmate is given the opportunity to present a short oral argument in a hearing before the court. He or she also may receive an evidentiary hearing to establish evidence for the petition. The habeas corpus concept was first expressed in the Magna Carta, a constitutional document forced on King John by English landowners at Runnymede on June 15, 1215. Among the liberties declared in the Magna Carta was that no free man shall be seized, or imprisoned, or diseased, or outlawed, or exiled, or injured in any way, nor will we enter on him or send against him except by the lawful judgment of his peers, or by the law of the land. This principle evolved to mean that no person should be deprived of freedom without due process of law. The writ of habeas corpus was first used by the common law courts in 13th and 14th century England. These courts, composed of legal professionals, were in competition with feudal courts, which were controlled by local landowners, or lords. The feudal courts lacked procedural consistency, and on that basis, the common law courts began to issue writs demanding the release of persons imprisoned by them. From the late 15th to the 17th centuries, the common law courts used the writ to order the release of persons held by royal courts, such as the Chancery, Admiralty courts, and the Star Chamber. The only reference to the writ of habeas corpus in the U.S. Constitution is contained in Article I, Section 9, Clause 2. This clause provides, the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. President Abraham Lincoln suspended the writ in 1861, when he authorized his Civil War generals to arrest anyone they thought to be dangerous. In addition, Congress suspended it in 1863 to allow the Union Army to hold accused persons temporarily until trial in the civilian courts. The Union Army reportedly ignored the statute suspending the writ and conducted trials under martial law. In 1789, Congress passed the Judiciary Act of 1789, ch. 20, 14, 1 Stat 73 codified in Title 28 of the USCA, which granted to federal courts the power to hear the habeas corpus petitions of federal prisoners. In 1867, Congress passed the Habeas Corpus Act of February 5, ch. 28, 14 Stat 385 28 USCA 2241 ETSEQ. This statute gave federal courts the power to issue habeas corpus writs for any person, restrained in violation of the Constitution, or of any treaty or law of the United States. The U.S. Supreme Court has interpreted it to mean that federal courts may hear the habeas corpus petitions of state prisoners as well as federal prisoners. The writ of habeas corpus is an extraordinary remedy because it gives a court the power to release a prisoner after the prisoner has been processed through the criminal justice system, with all its procedural safeguards and appeals. For this reason, the burden is initially on the petitioning prisoner to prove that he or she is being held in violation of a constitutional right. If the petitioner can meet this burden with sufficient evidence, the burden then shifts to the warden to justify the imprisonment. Ruben Hurricane Carter federal courts grant writs of habeas corpus only when grave constitutional violations have occurred. The granting of Ruben Hurricane Carter's habeas petition in 1985 freed him from almost 20 years of imprisonment for a crime he maintains he did not commit. Carter was a top-ranked middleweight boxer when he and John Ardis were arrested in 1966 and charged with murdering 3 people in Paterson, New Jersey. Carter and Ardis were African American, the victims were white. Carter and Ardis claimed they were the victims of racism and a police frame-up, but they were convicted of murder and sentenced to life imprisonment. Carter fought his conviction in state court, but the verdict was upheld. In 1974 he published The 16th Round, from number 1 contender to number 45,472. The book became a national bestseller and drew attention to his case. In 1975 Bob Dylan wrote and recorded the song Hurricane, which recounted Carter's arrest and trial and characterized Carter as an innocent man. This publicity, along with an investigation by the New Jersey Public Defender's Office, led to a motion for a new trial. The motion was granted, but Carter and Ardis were convicted again in 1976. Carter remained imprisoned, Ardis was paroled in 1981. After all state appeals were exhausted, the only remaining avenue for relief was to file for a writ of habeas corpus in federal court. In November 1985 Judge H. Lee Sarakin ruled that the second murder trial convictions were unconstitutional because the prosecution had been allowed to imply that guilt could be inferred by the defendant's race and because the prosecution withheld polygraph evidence that could have been used to impeach the credibility of their star witness, Carter v. Rafferty, 621 F. Sup. 533 DNJ 1985. Judge Sarakin therefore granted habeas corpus, overturned the convictions, and ordered immediate release from custody with prejudice. The state of New Jersey appealed to the Third Circuit Court of Appeals, asking to reverse Sarakin's ruling and requesting that Carter remain incarcerated until a final ruling. The Third Circuit rejected both appeals. New Jersey appealed to the U.S. Supreme Court, which also refused to overturn. The state chose not to attempt a third prosecution of Carter and Ardis. Carter moved to Canada where he headed the Association for the Defense of the Wrongly Convicted. A prisoner may file a petition for a writ of habeas corpus with the sentencing court only after exhausting all appeals and motions. Federal courts may receive a petition from a state prisoner, but not until the petitioner has attempted all available appeals and motions and habeas corpus petitions in the state courts. Federal prisoners must exhaust all available appeals and motions in the federal sentencing court and federal appeals courts before filing a habeas corpus petition with the sentencing court. If the first petition is denied, the inmate may petition the appeals courts. A petition for a writ of habeas corpus is a civil action against the jailer. It is neither an appeal nor a continuation of the criminal case against the prisoner. It is not used to determine guilt or innocence. Rather, the purpose is solely to determine whether the confinement is in violation of a constitutional right. This is significant because it limits the scope of complaints that a petitioner may use as a basis for the writ. Violation of the due process clauses of the 5th and 14th Amendments is the most common basis for a writ of habeas corpus. Prosecutorial misconduct, juror malfeasance, and ineffective assistance of counsel are common due process grounds for the writ. Fifth Amendment grounds include failure of the police to give Miranda warnings before in-custody questioning, in violation of the right against self-incrimination, and multiple trials, in violation of the double jeopardy prohibition. The Eighth Amendment right against cruel and unusual punishment is another common ground for habeas corpus relief, especially in cases involving the death penalty or a lengthy prison term. There are several notable restrictions on the writ's application. Fourth Amendment violations of the right against unreasonable search and seizure cannot be raised in a habeas corpus petition. Prisoners are not entitled to a court-appointed attorney for habeas corpus petitions. Newly developed constitutional principles will not be applied retroactively in habeas corpus cases except where doubt is cast on the guilt of the prisoner. Delay in filing a habeas petition may result in its dismissal if the government is prejudiced, i.e., made less able to respond, by the delay. In addition, the petitioner must be in custody to request a writ of habeas corpus. This rule prevents a prisoner from challenging a conviction through habeas corpus after serving out a sentence for the conviction. The law of habeas corpus is ever-changing. In the 1990s, the U.S. Supreme Court took steps to further limit the writ's application. In Keeney v. Tamayo-Reyes, 504 U.S. 112 SCT 1715, 118 L. ed. 2d 318, 1992, the court held that a habeas corpus petitioner is not entitled to an evidentiary hearing in federal court unless she or he can show two things: a reason for failing to develop evidence at trial, and actual prejudice to the prisoner's defense as a result of the failure. In Herrera v. Collins, 506 U.S. 390, 113 SCT 853, 122 L. ed. 2d 203, 1993, the court held that a claim of actual innocence is not a basis for federal habeas corpus relief. This means that newly discovered evidence alone does not entitle a petitioner to federal habeas corpus relief. The availability and import of habeas corpus in state courts is also subject to change through judicial decisions and new laws. For example, in 1995, the Texas legislature passed a law that made the habeas corpus process concurrent with appeals, Texas CRIMPROC Code and Art 11.071. This law effectively limited the number of times that a Texas state prisoner could challenge the disposition of a criminal case. Significantly, the law applied to all criminal defendants, including those facing the death penalty. Under the legislation, a death row inmate has only one round of review in Texas state courts before seeking relief in federal court. In 1996, Congress passed the Anti-Terrorism and Effective Death Penalty Act, EDPA, PUBL No. 104-132, 110 STAT 1214. Congress sought to streamline post-conviction appeals proceedings and to curtail the time that prisoners could use to seek habeas corpus relief. Since the enactment of the law, the U.S. Supreme Court has been called upon to interpret a number of the EDPA provisions. These rulings primarily have addressed technical details of the workings of the new law, but the court has endorsed the EDPA and removed jurisdiction from the lower federal courts to hear many habeas petitions. The court upheld the constitutionality of the EDPA in Felker v. Turpin, 518 U.S. 651, 116 SCT 2333, 135 L. ed. 2d 827, 1996. The habeas corpus provisions represent a major shift in federal-state judicial relations, for Congress directed that federal courts generally defer to state court judgments on questions of federal constitutional law in criminal cases. The EDPA established a deference standard, which mandates that the federal courts, in reviewing state court convictions, defer to a state court ruling on the merits of any habeas corpus claim. This deferral includes questions of fact and of law, as well as mixed questions of fact and law. A federal court must defer unless the state court adjudication of the claim resulted in a decision that was contrary to, or involved an unreasonable application of, clearly established federal law, as determined by the U.S. Supreme Court, or if the state conviction resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. The EDPA also contains a number of specific rules for habeas corpus review. The Act provides for a one-year filing deadline for non-capital habeas corpus petitions. The time starts running at the conclusion of direct review or expiration of time for seeking such review. The law requires a certificate of appealability from a circuit judge or justice before a petitioner may appeal from denial of relief. The petitioner must make a substantial showing of denial of a constitutional right, and the certificate must be issue-specific. The EDPA also allows federal courts to deny relief with respect to unexhausted claims but may not grant relief if the claim is unexhausted. The habeas petitioner can avoid exhaustion only if there is no available state remedy or the remedy is ineffective to protect the petitioner's rights. If there is no state remedy because of a procedural default, federal review is still prohibited. The EDPA also places restrictions on the ability of a petitioner to obtain an evidentiary hearing on a claim where the prisoner failed to develop the factual basis. Because state court fact findings are presumed to be correct, the petitioner must rebut the presumption by clear and convincing evidence. To obtain an evidentiary hearing, the petitioner must show that the claim relies on a new rule made retroactive by the U.S. Supreme Court or that the factual predicate could not have been discovered earlier through due diligence. Moreover, in all cases, the petitioner must show by clear and convincing evidence that but for the alleged error for which a hearing is sought, no reasonable fact finder would have found petitioner guilty of the underlying offense. This is a steep hurdle for a habeas petitioner to overcome. The EDPA also seeks to prevent the abuse of habeas corpus by limiting the number of times a prisoner may ask for a writ. A successive habeas petition may not be filed in district court unless the petitioner is authorized to do so by a 3-judge panel of the Court of Appeals. The U.S. Supreme Court, in Felker, characterized this provision as an acceptable gatekeeping mechanism. If petitioners make a prima facie showing that they satisfy the exceptions against successive petitions, they may proceed, otherwise the court must dismiss the petition. If a successive claim was presented in a prior petition, it must be dismissed. No exceptions are authorized by the EDPA. Though the EDPA provides some narrow exceptions to this rule, any claim must establish by clear and convincing evidence that but for the error no reasonable fact finder would have found the petitioner guilty of the underlying offense. In habeas petitions from death row inmates, the EDPA imposes additional rules beyond those already described. The rules apply to states that establish certain standards for competence of counsel. For states to benefit from these additional limitations, they must provide a mechanism for appointment and compensation of competent counsel in state post-conviction proceedings or for appointment of counsel to handle the appeal and post-conviction remedies in a unitary proceeding. Once the state court has made an appointment of counsel, a federal court that would have jurisdiction over the case may enter a stay of execution. The stay expires if a timely petition is not filed, if the prisoner properly waives the right to pursue federal habeas relief, or if relief is denied at any stage of federal review. Once a stay vacates under any of those circumstances, a new one may not be imposed unless the petitioner can overcome the presumption against successive petitions. The EDPA sets a time limit for habeas petition in capital cases. The petition must be filed within 180 days after final state court affirmance on direct review. In addition, the EDPA requires that capital habeas cases be given priority over all non-capital matters, and it imposes time limits on resolution. These include a decision by the district court within 180 days after the petition is filed, although the court may extend its time by no more than 30 days. Failure by the district court to act within the time limits may be enforced by a petition for writ of mandate. More importantly, a court of appeals must decide the case within 120 days after the reply brief is filed. Any petition for rehearing must be decided within 30 days after the petition is filed, or 30 days after any requested responsive pleading is filed. If rehearing or rehearing en banc is granted, the case must be decided within 120 days after the order granting such rehearing. In addition, the time limits are applicable to all first petitions, successive petitions, and habeas cases considered on remand from a court of appeals or the U.S. Supreme Court. The EDPA has changed the legal landscape for prisoners seeking writs of habeas corpus. Petitioners must act within set deadlines, and they must attempt to place all issues in dispute before the first habeas reviewing federal court or risk the chance of being rejected in a successive petition. Persons entitled to writ. Exceptions Section 1. Whoever is imprisoned or restrained of his liberty may, as of right and of course, prosecute a writ of habeas corpus, according to this chapter, to obtain release from such imprisonment or restraint, if it proves to be unlawful, unless first, he has been committed for treason or felony, or on suspicion thereof, or as accessory before the fact to a felony, and the cause has been plainly expressed in the warrant of commitment. Second, he has been convicted or is in execution upon legal process, civil or criminal. Third, he has been committed on mean process in a civil action in which he was liable to arrest and imprisonment, unless excessive and unreasonable bail was required. Section 2, by whom issued. Section 2. The writ may be issued, irrespective of the county in which the person is imprisoned or restrained, by the Supreme Judicial or the Superior Court, by a probate or a district court or by a judge of any of said courts.
Reading from the 192nd General Court of the Commonwealth of Massachusetts. It was Section 1 and Section 2. And before that was from a free law dictionary that can be found online. I posted the link on the screen. Just doing a little bit of follow-up research about writs tonight, namely writs of habeas corpus.
Section 3, Petition for writ. Contents, Annexed Papers. Section 3. The petition for the writ shall be in writing, signed and sworn to by the person for whose release it is intended, or by a person in his behalf, and shall state by whom and where the person is imprisoned or restrained, the name of the prisoner and of the person detaining him, if their names are known, or a description of them, if their names are not known, and the cause or pretence of such imprisonment or restraint, according to the knowledge and belief of the petitioner. If the imprisonment or restraint is by virtue of a warrant or other process, a copy thereof shall be annexed, unless it appears that such copy has been demanded and refused, or that, for a sufficient reason, a demand therefore could not be made. Section 4, Issuance of writ. Return. Section 4. The court or magistrate to whom the petition is presented shall, without delay, issue a writ of habeas corpus, substantially in the form heretofore established and used in the Commonwealth, and returnable forthwith to the Supreme Judicial Court, or a justice thereof, at such place as shall be designated in the writ. Section 5, Form of writ. Section 5. If the imprisonment or restraint is not by a sheriff, deputy sheriff, or jailer, the writ shall be in the following form, Commonwealth of Massachusetts. Seal. To the sheriffs of our several counties and to their respective deputies, greeting. We command you that the body of, imprisoned and restrained of his liberty, as it is said, you take, and have before a justice of our Supreme Judicial Court at immediately after the receipt of this writ, to do and receive what our said justice shall then and there consider concerning him in this behalf, and summon said then and there to appear before our said justice to show the cause of the taking and detaining of said, and have you there this writ with your doings thereon. Witness at this day of in the year. Section 6. If the writ is issued by the court when sitting for the transaction of business, it shall be signed by the clerk, otherwise by the magistrate issuing it, and may be served in any county by any sheriff or deputy sheriff. Section 7. The person who has the custody of the prisoner may be designated by his office or by his own name, or, if they are unknown or uncertain, he may be described by a fictitious name, and the person upon whom the writ is served shall be held to be the person intended. Section 8. The person restrained shall be designated by name, if known, otherwise, he may be so described as to identify him. Section 9. If the person restrained is confined in jail or is in the custody of a civil officer, the court, or magistrate granting the writ shall certify thereon the amount to be paid for the expense of transporting him from the place of imprisonment, and the officer shall not be bound to obey the writ unless that amount is paid or tendered to him. Section 10. Any person to whom the writ is directed shall receive it, and, upon payment or tender of the charges demandable for its execution, shall make due return thereof within 5 days after receiving it. Section 11. The person in whose custody the prisoner is found shall state in writing, plainly and unequivocally, to the court or justice before whom the writ is returnable first, whether the prisoner is in his custody or power or under his restraint. Second, if the prisoner is in his custody or power or under his restraint, his specific authority for and the true and whole cause of such imprisonment or restraint, with a copy of the writ, warrant, or other process, if any, upon which the prisoner is detained. Third, if the prisoner has been in his custody or power or under his restraint, and has been transferred to that of another, particularly to whom, when, why and by what authority such transfer was made. The statement shall be signed by him and, unless he is a sworn public officer and makes the statement in his official capacity, shall be sworn to by him.
Breaking news: Moorish American national Quinn Kabir Il from Rise of the Moors, who was kidnapped and held hostage for profit on July 3, 2021, invoked his treaty right to consular jurisdiction and challenged the jurisdiction of Malden District Court (parentheses incorporated) via writ of quo warranto (parens Exhibit A). Morocco Consulate Court at the Maryland State Republic issues writ of habeas corpus, which ordered for the immediate release of Quinn Kabir Il from unlawful imprisonment.
Section 11. The person in whose custody the prisoner is found shall state in writing, plainly and unequivocally, to the court or justice before whom the writ is returnable first, whether the prisoner is in his custody or power or under his restraint. Second, if the prisoner is in his custody or power or under his restraint, his specific authority for and the true and whole cause of such imprisonment or restraint, with a copy of the writ, warrant, or other process, if any, upon which the prisoner is detained. Third, if the prisoner has been in his custody or power or under his restraint, and has been transferred to that of another, particularly to whom, when, why and by what authority such transfer was made. The statement shall be signed by him and, unless he is a sworn public officer and makes the statement in his official capacity, shall be sworn to by him. Section 12. The person who makes the statement shall at the same time produce the prisoner, if in his custody or power or under his restraint, according to the command of the writ, unless prevented by the illness or infirmity of the prisoner. Section 13. If by reason of the illness or infirmity of the prisoner he cannot without danger be taken to the place appointed for the return of the writ, that fact shall be stated in the statement and, if proved, the judge may proceed to the place where the prisoner is confined and there make his examination, or he may postpone the examination or may make such other order in the case as law and justice require. Section 14. If the court to which the writ is returnable is not sitting for the transaction of business when the writ is returned, the return shall be made before a justice thereof. If the writ is returned before a justice when the court is sitting for the transaction of business, he may adjourn the case into the court, to be there heard and determined. Section 15. After the writ has been returned, the prisoner may deny any of the facts set forth in the statement and may allege any other material facts, and the court or justice shall examine summarily and without delay the causes of the imprisonment or restraint, hear the evidence produced by any persons interested or authorized to appear and dispose of the prisoner as law and justice require, and may adjourn the examination from time to time. Section 16. If it appears from the return of the writ or otherwise that the prisoner is detained on a process under which another person has an interest in continuing his imprisonment or restraint, he shall not be discharged until notice has been given to such other person or his attorney, if within the Commonwealth. If such person or his attorney is not within the Commonwealth, the court may order notice to be given to him.
I'm going to play it again. This is the 192nd General Court of the Commonwealth of Massachusetts, Chapter 248, Section 16. Notice to persons interested in continuing imprisonment.
Section 16. If it appears from the return of the writ or otherwise that the prisoner is detained on a process under which another person has an interest in continuing his imprisonment or restraint, he shall not be discharged until notice has been given to such other person or his attorney, if within the Commonwealth. If such person or his attorney is not within the Commonwealth, the court may order notice to be given to him.
So this is going to be a really big, involved process, right? I mean, there's still a ways to go yet with this, folks. There's still a ways to go, and I would read the rest of the or have the rest of the statutes read, but as you can see, it's pretty labor intensive. There's a lot of sections here. As a matter of fact, under chapter 248 itself, I counted up to, let's see, 40 sections. 40 sections on habeas corpus. 40 of them. Habeas corpus and personal liberty. There's all the headings right there. As a matter of fact, I want to try something real quick and just go down the titles here, just to be clear and make it well understood that this is still a process. There's still a process involved in this, and there's a number of steps that this must undergo.
Section 1 Persons entitled to writ. Exception Section 2 By whom issued. Section 3 Petition for writ. Contents. Annexed papers. Section 4 Issuance of writ. Return. Section 5 Form of writ. Section 6 Signature of magistrate or clerk. Service. Section 7 Designation of custodian of prisoners. Section 8 Designation of prisoners. Section 9 Expense of transporting prisoner. Advance payment. Section 10 Return of writ. Section 11 Contents of return. Section 12 Production of prisoners. Section 13 Illness preventing production of prisoners. Section 14 Return before justice of court. Section 15 Causes of imprisonment. Examination. Section 16 Notice to persons interested in continuing imprisonment. Section 17 Notice prisoners held for crimes. Section 18 Custody of prisoner pending examination. Section 19 Bail. Section 20 Prisoners committed in civil actions for want of bail. Bail. Section 21 Prisoners committed on criminal charges. Bail. Section 22 Remanding prisoners. Section 23 Discharging prisoners. Section 24 Imprisonment after discharge. Section 25 Scope of chapter. Section 26 Refusal of officer to deliver copy of warrant. Penalty. Section 27 Refusal to obey writ. Attachment. Section 28 Attachment. Executing officers. Section 29 Refusal to obey writ. Precept commanding production of prisoners. Section 30 Refusal to obey writ. Penalty. Section 31 Resistance or disobedience of writ. Attachment. Section 32 Removing or concealing prisoner. Penalty. Section 33 Recovery of penalties. Effect on actions by aggrieved parties. Section 34 Persons in custody of United States Marshal. Section 35 Personal liberty, how secured. Section 36 Petition to obtain personal liberty. Section 37 Notice to custodians, etc. Section 38 Examination of witnesses. Section 39 Conducting examinations, assistance from district attorneys. Section 40 Payment of fees.
Needless to say, there's still a lot to consider with this matter, a lot to unpack as associated with this situation. But it's a step nonetheless.
On August 18, 2021, the writ of habeas corpus ad subjiciendum was received and entered into the records of case number 2150 CR 001097 of the Foreign Malden District Court, Inc., and ordered for the immediate release of Quincumber LX Rel. Quincumberlander, ID #071-1662 from the custody of the foreign hybrid European male Fulton Holland, acting as Warden of the Foreign Corporate Entity Worcester County Jail and House of Corrections, Inc., and the Foreign Hybrid European Male Louis G. Evangelides, acting as Sheriff for Worcester County, Massachusetts. The below writ of habeas corpus ad subjiciendum is enforceable pursuant to the full faith and credit clause under Article 4, Section 1 of the Constitution for the United States of North America.
you.